Okay, everyone, let's go ahead and get started. So good afternoon and welcome to the Committee for Justice's virtual panel. This one is on lessons from 2 years of GDPR and whether or not Europe's data privacy regulations belong on this side of the Atlantic and lessons learned for policymakers. I'm your host, Ashley Baker, and I'm the Director of Public Policy at the Committee for Justice. I'm now going to introduce the panelists in the order in which they will present. Roslyn Layton is a visiting scholar at the American Enterprise Institute, where she focuses on evidence-based policy for information, communications, and digital technology industries. Using empirical methods, she assesses regulations and the policies for digitally connected domains. Dr. Layton is also a visiting researcher at Aalborg University Center for Communications, Media, and Information Technologies, and a vice president of Strand Consult, both in Denmark. Dr. Layton served in the 2016 to 2017 Federal Communications Commission Presidential Transition Team. She has worked on the adoption of technology by emerging countries, produced independent research on the mobile technology industry, and studied issues such as information technology, telehealth care, and fintech for a variety of firms. She has worked in Europe, India, and the United States. Andrew Kingman is a senior managing attorney in DLA Piper's Global Data Privacy and Cybersecurity Practice Group, where he counsels clients on U.S. state privacy and cybersecurity laws, regulations, and compliance. As General Counsel to the State Privacy and Security Coalition, he represents leading technology, media, communications, healthcare, automotive, payment card, and retail companies as a legislative strategist and advocate on cybersecurity and privacy issues at the forefront of the policy arena in all 50 states. He has worked on every sector of major state privacy legislation, including CCPA, Washington Privacy Act, biometric privacy, facial recognition, student privacy, geolocation information, data breach notification, and online political advertising. He is a member of the Oregon Attorney General's Legislative Task Force on Privacy and is an official observer to the Uniform Law Commission's drafting process on model privacy legislation. In 2020, he was selected as an up-and-coming lawyer. Pam Dixon is the founder and executive director of the World Privacy Forum. An author and researcher, she has written respected and influential studies in the area of privacy, identity, biometrics, artificial intelligence, health privacy, and other topics. Without Consent is a 4-year privacy benchmark study of 5,000 educational institutions in the United States. In 2019, Dixon served as rapporteur for the first roundtable of the African Data Protection Authorities regarding identity systems. Sorry about that. She conducted substantive biometrics research in India and wrote a scholarly article analyzing India's Aadhaar biometrics and EU-US data policies called A Failure to Do No Harm. This work was cited in 2018 Supreme Court of India's landmark Aadhaar decision. Dixon has written 8 books and numerous other privacy studies, including The Scoring of America, a groundbreaking report on AI. She has served as an expert advisor to OECD on health data and also on AI and machine learning. So, just a few housekeeping notes. So if any of you guys have questions for the panelists, so we're going to do first remarks and then we're going to engage in a bit of a discussion. At the end, I'll start asking them questions from the audience. You can go ahead and send me those questions through the Zoom Q&A feature you see at the bottom of your screen. And that way I'll just introduce them at the end for you to make things a little bit easier. And Roslyn, the floor is yours.
Great. Well, hello everyone, and thank you to the Committee for Justice for inviting me. It's such a privilege to be with so many esteemed colleagues. Pam and Andrew, thank you to share this platform with you today. I wanted to make some brief remarks just to kick us off. We are here at the 2nd anniversary of the General Data Protection Regulation of the European Union, and I have followed this very closely. I've lived in the EU for the last 10 years, and the GDPR follows on a successive wave of data protection regulation. There was a cookie directive. There have really been many things, and it's interesting that this particular anniversary is really passed without the European Commission or Parliament saying very much about it. So I think it's helpful to review some of the highlights, particularly if we look at the rhetoric 2 years ago when this law was put into place. It was really heralded as to change the playing field, and it would bring about these giant fines and all of the players we put into their place and so on. And 2 years hence, it's really not the case. I have an article on American Enterprise Institute about this. You can just put GDPR in the search bar. A lot of our scholars cover this issue. There's also a helpful privacy tracker, privacytracker.com, which also lists the enforcements, the fines, the types of enforcements, which countries are doing the enforcements, but it's helpful to have an overview. So in the last 2 years, there's been about 275 finalized enforcements. Of course, there's other cases going on. And the fines that have been handed down, they range between 90 euros and 50 million euros. Most of the fines are in the range of about a few hundred to a few thousand euros. Total fines are 150 million euros. But if you think about those numbers of fines, if you compare the cost to running a data protection agency, that is really a drop in the bucket. It costs a lot more money to run an actual DPA. There's 27 across the European Union today. And as UK is no longer part of the EU, they, of course, still are enforcing the GDPR in the UK. What's interesting about these fines is that they are largely about the misuse of personal information in healthcare, on banking statements, in areas of employment, and in other, these are areas where there's really a lot of established protections for in the United States. And so, you know, whereas the number of enforcements against the large Silicon Valley platforms are limited, with one particular exception around Google, where there's a $50 million fine. And that is, it was really not, for example, what we were told that this was kind of how the European Union was going to slap down Google. It was actually a rather minor infraction, even though the fine level is quite large. So what has gone on in the EU is quite a lot of compliance, many billions of dollars of compliance. A typical large firm would spend between $1 to $3 million to comply with the GDPR. And what's interesting is you have quite good compliance. I mean, in terms of the highest level of compliance is with the large technology companies themselves, both American and European. And they, and whereas the small and medium-sized enterprises, many of them are limited compliance or no compliance at all. This is something that the regulatory policy people predicted, that the cost was going to be that you get a lot of compliance from the large firms. This would end up being a market advantage to them. And we can also see that in these 2 years, the market share of the largest Silicon Valley firms has increased. Small, long tail advertising companies, a lot of them have closed, they've exited. So in some ways, one could actually say the competition has been reduced. We've certainly seen in a lot of studies, venture capitalism has certainly been lessened because the environment is less conducive to risk-taking and innovative uses of data. The other thing to point out is that we haven't seen, whereas we were told to expect that there would be these major fines, you know, 4% of revenue, no DPA has come forward with something like that. As I said, the largest was Google with $50 million. Compare that to the Federal Trade Commission in the United States, which has a $5 billion fine against Facebook and major conduct relief. That fine is 20 times what would be what you could get under the GDPR. So the Federal Trade Commission, without any new laws at all, is able to use its existing authority to put on a $5 billion fine on Facebook, obtain major conduct relief, and sort of shape the Facebook of the future to its preferences, which in some ways was ostensibly the goal of the GDPR, but they are not going down that road. I think it's quite interesting because many of the advocates for the GDPR really attempted to import a kind of litigation culture from the United States. They wanted to have class actions. There are 3 provisions of the GDPR that lets you set up a nonprofit organization. You can represent a class of actors. You can conduct complaints to your DPA. You can get redress and collect the payout, if you will. And that really hasn't happened. Now, We were also told as well that it might be 2 years before major cases to be resolved. And again, but I think that the DPAs have been reluctant to do that because they don't want to be in court forever. They don't want to fight long court battles to defend extremely large kinds of fines and so forth. So I think it's a very interesting experience for the US to learn, particularly because the GDPR was called the gold standard. It was going to achieve all of these things. It was going to change the playing field. It was going to make these giant fines. And 2 years hence, we really don't see that. Now, things could change in the future. Again, it's 2 years. But I think what's most interesting as well is that what the data protection agencies decide to enforce have largely been areas where there is already existing privacy protections in the United States, particularly financial, health, banking laws, and so forth. Whereas we thought that the GDPR was largely going to open this new domain to go after the tech companies. It has yet to happen. So I have some more comments for later, but if that's sufficient to kick us off, Ashley, I know our other colleagues have a lot to offer on this topic.
So Andrew, I think you were going to talk a bit about the states and some other issues.
Yep, absolutely. Thanks. And again, thanks, Ashley, and thanks everybody else for joining today. Really appreciate it. It's springtime and I do a fair bit of gardening, and I've been trying to eradicate bittersweet from my garden, but it keeps popping up everywhere. And I think when we think about how GDPR has affected the laws and sort of the privacy landscape in the United States, it's a nice analogy. Whether it's in CCPA, whether it's in federal legislation that we see, whether it's in other places like the Washington Privacy Act, which we'll talk a bit about today, it's hard to deny that GDPR, Roslyn can talk about its efficacy in Europe, but it's hard to deny that it has certainly helped to frame the debate both at the federal and state level in the United States. I think that, as hopefully everybody on this call knows, the California Consumer Privacy Act, it's probably GDPR's clearest US progeny in terms of a law that's actually been enacted, just in terms of a focus on consumer rights and consumers' ability to control their own data. I think it's interesting to contrast the way that it was passed. GDPR was a very deliberative process over many years with a 2-year ramp up before it went into effect. The CCPA was passed in less than a week and passed both chambers and was signed by the governor in a single day, which is legislative efficiency that we can all dream about. My thesis today is that I think it's unlikely that any state will pass comprehensive privacy legislation in the next several years. And I have several reasons why. I think one is that the two most developed proposals, the CCPA and the Washington Privacy Act, have not propagated, and obviously in the Washington Privacy Act case, failed to be enacted for 2 straight legislative sessions. 2 is states focus more on COVID. I think there'll be fewer states putting forth comprehensive and omnibus proposals. In the states that do, there's going to be a higher level of intensity to that debate because it's going to be a much more focused, the stakes are higher. Both the privacy advocates and the business community will be very attuned to the few states that do put forward those proposals. And then I think also in a post-COVID world, I'm not sure, I'll be really interested to see whether the evolution of consumer control may give way to more concerns about regulating where and how a business collects and processes personal data and the regulations around what it can do with that data. CCPA is one of several approaches that states have tried. It has been rejected wholesale in other states that have considered it, states like Massachusetts, Maryland, Texas, Connecticut, for two main reasons. One is the cost and economic impact to small businesses. The California AG's office came out with a study earlier this year suggesting that initial compliance costs for businesses would be $55 billion, and that for companies with less than 20 employees, Those costs would be about $50,000 for companies with less than 50 employees. Those costs rise to about $100,000. And there just aren't a lot of state legislators that are willing to take on that kind of economic impact in their state. And again, I think in a post-COVID world, that will be emphasized. I think also CCPA is yet to be a finished product. Part of the statute is in effect. We're still waiting on regulations that now look like they may be delayed until, in terms of their effective date, until October. And although the AG has said that he will start enforcing the existing statute as of July 1. But we're also waiting on the CPRA ballot initiative, which makes substantial changes to the CCPA. And so, other states aren't really willing to put forth proposals if they think that it's going to be obsolete, once the November elections happen. There are other approaches that states have tried. Nevada in 2019 passed a relatively narrow bill that gave consumers an opt-out of sale right for particular types of data. Nevada had followed California in 2016 in passing the Online Personal Protection or Personal Privacy Act, Nevada APA. And so there's a delineated list of covered information there that an individual can opt out of. There have been some opt-in consent bills that have been proposed where it's wholesale opt-in consent for all types of information, whether it's collection, disclosure, sale, et cetera. That we've seen that in North Dakota. Then there have been some hybrid approaches like Texas and Louisiana. We've also seen the New York Privacy Act be filed last year. And although I think that was a little bit overhyped considering that it had a relatively short lifespan, but was sort of novel for introducing the idea at a state level of a data fiduciary concept. And then we have the Washington Privacy Act. And I think the Washington Privacy Act is probably the best case study that illustrates the current dynamics and boundaries of the privacy debate at the state level. And we can talk more about it in our questions, but I would say, all of the groundwork was there to have a bill pass the legislature. There was an engaged legislator, the sponsor, Reuven Carlisle, who was willing to do the work and was committed to seeing a particular outcome happen. I think there was a general sentiment among the business community and a degree of acceptance that something was likely to pass. And so the focus from the business community was on the substantive parts of the bill and making it better and more workable. I think there was general agreement that it was cleaner and more workable than the CCPA. It was much easier for entities to understand, which would lower compliance costs. But I think that the House committee and some of the privacy advocates really overreached there. And I think, when the bill passed the Senate, they could have had a privacy bill at that point that would have really meaningfully, advanced privacy in the states. And, unfortunately, the elephant in the room was the private right of action and the enforcement mechanism. The business community made it clear, as well as the sponsor, that was a non-starter, and the House inserted a private right of action, and that was why it died in conference committee in the final hours of the session. So I think going forward, we're going to see more narrow sectoral bills, sort of a pre-CCPA landscape of bills that are trying to regulate facial recognition, geolocation, and some legislation that is going to be COVID specific related to contact tracing. We're already seeing a couple of those bills emerge in New York and California. So, I think, again, we may be moving towards what my colleague Pam likes to call small p privacy, and I will turn it over and let her speak to that a little bit.
Thank you.
Hello, and thank you, Ashley, for your invitation. It's great to be here, and it's so good to see everyone in this new world. So I'm just going to talk about three things in thumbnail form: GDPR, silos and standards, and what I call big privacy. So let me start with the GDPR. So I think something that tends to get lost in the discussions, the modern discussions of GDPR, is that it's actually built on something else, which is the EU 9546, which was the original data protection directive. That directive was in place for 25 years before GDPR discussions began, and it developed a huge bureaucracy around it. So there were a lot of procedures in place. Businesses had, an understanding of kind of the architecture of data protection in Europe prior to the GDPR. And of course, data protection authorities already existed prior to the GDPR. So there was a very meaningful context for the GDPR within the EU. Now, when GDPR came along and it went into something called trilogue, there was a lot of discussion. It was extraordinarily deliberative, as others have said here, and it built upon the EU 9546. It wasn't, fabricated out of whole cloth whatsoever. Now, in the new version, I shouldn't say new version, in GDPR, there were some meaningful changes. There were very important changes around data security and data breach notification. And that doesn't get discussed very much, but those were positive changes. There were also changes in regards to certain rights that were conferred upon individuals, including the right to be forgotten, certain consensual rights, automated profiling, and other things like that. But there's a part of GDPR that's not discussed very frequently that's actually really important, which are the latter sections on codes of conduct. And it's through the codes of conduct that we're seeing a lot of activity in regards to actually implementing GDPR. And I think that the Data Protection Authority who's doing the most extraordinary job on this is actually in the UK, Elizabeth Denham. She's written quite extraordinary codes of conduct. And what she's done, I really like. She's gathered all of the stakeholders in the room, and she calls them very noisy rooms, which is, of course, I love this. This is what you want. You want all the voices. And she goes through the process, and it can take a little longer than a weekend. Actually, it takes quite some time, but she's come up with some really excellent codes, and her most recent code was on children and design specifications for kids, and it was extraordinary, and it was extraordinarily well done, and you could really see the voices of all of the stakeholders. And I think this is just a really good side of GDPR, and it's overlooked a lot. But I think that if there's something that the US can take from GDPR, it's to also include a focus on meaningful, creating meaningful standards in the way that the GDPR has also, put forward. And that brings me to the second point, which is silos versus standards. So Andy mentioned the Washington bill. I was very concerned about the Washington bill, and I have been very concerned about CCPA. There are some unintended consequences that we're seeing already from CCPA. And it's difficult to discuss anything about CCPA without being immediately put into some kind of, labeling exercise or corner. So I'd like to really remove myself from that as much as is possible and speak as neutrally as I can and as factually as I can about this. The fact is that the mechanism, the construct of the way CCPA acts is that the businesses have to collect a lot of data about consumers in order to effectuate the new consumer rights. And on theory and on paper, that's fabulous, right? But at the end of the day, businesses have to collect consumer data. It has to be accurate. There has to be identity checks. So all of these things become a double-edged sword, and you end up with silos all over in all of these businesses replicating silos. And when I was in India doing the research on the Aadhaar biometric ID in India, this silo problem was one of the very significant problems we ran into. And it ultimately led to the failure of the Aadhaar as a major, multi-platform, multi-system identity program because of the silo effect, where you had everyone's identity just being replicated over and over and over again. It leads to, I've seen what that looks like when it's mature, and I've seen the end point of what it does, and it's really messy, and it really decreases a lot of autonomy and privacy for individuals and also for groups, and it's also enormously inefficient. And that brings me to the idea of standards. I think most people, definitely all of us here, know that Professor Jane Wynn and I worked on a bill in regards to voluntary consensus standards in the US. And we were really hoping that one of the privacy bills at the federal level would just pick it up and put it on as like a building block. It would act a lot like the codes of conduct in GDPR. Whereas it's not industry self-regulation, it's really a situation where voluntary consensus standards are actually part of the law here in the US. They require due process. They require all stakeholders to have a voice. They require fairness and non-dominance. It's a really good system, and they've been in place and been used for about 20 years now. They were originally written and used as part of a government modernization program, but they were built on existing ideas that were already around in the standards process. And if we had standards for privacy, we would have ways to measure how effective our privacy legislation is being or is performing. Something, and this brings me to the idea of what I call big privacy. One of the biggest situations that we're facing in the privacy world is the deep innumeracy. And we just published a report. It was 4 years in its research. It's called Without Consent. It's basically, it was a longitudinal study of more than 5,000 schools from K through university. And what it does is it benchmarks certain data flows and data issues at, in that context in regards to the Family Educational Rights and Privacy Act, or FERPA, our federal student privacy law. And we wanted to do this so that it would provide numeracy in regards to where the problems are. And we had theorized where some of the problems were. Some of those hypotheses were correct and some were incorrect. We found problems we didn't expect to find, and we found things that were really great that we thought might be a problem. And that's the entire point of adding data to the discussion. And I think that if we're going to have what I call big privacy that costs a bundle and puts extraordinary compliance burdens into the ecosystem, we have to back that up with data. We have to know for real. We have to really know and be able to articulate and prove with evidence where the problems are. And we can't be guessing about that. However, that being said, where we do find problems, we need to act. So again, more double-edged swords, but privacy is a complex issue, but at the same time, it does yield to problem solving as long as you're problem solving with data.
Thank you, Pam. So I thought your points, particularly about the voluntary consensus standard, were really interesting, and I'd really like to get back to those in just a moment. But since you guys have so much expertise, and that's just so much information right now for everyone to wrap their heads around, can each of you, or all of you, or any of you, talk a little bit about what do you think are really the fundamental misunderstandings in this privacy debate, whether it's from a compliance standpoint, like what you're seeing with your clients, what you're seeing more on a state level. Most people who are engaged in the privacy debate just see the big picture, and you guys have really been in the trenches. So what would you say some of those misunderstandings boil down to?
I can respond to that. I'll just take a quick stab. There's a lot. I think certainly one of the misunderstandings is the role of consent. So a lot of my work deals with human subject research and research protocols, and this requires consent. And by consent, I mean extraordinarily meaningful consent. It is part of the Nuremberg Code that any subject of human research should have meaningful consent, and I believe in this with my whole heart. there are also other situations where we need very meaningful consent, and we must have true choice about whether to engage in something or not. So we need to have a very robust dialogue about where do we need this kind of consent. And I don't think we've really had a fulsome dialogue about this, but we need to have that. But beyond that, having consent become a tick box or a checkbox is deeply problematic. It's not privacy. Consent is not equivalent to privacy. It's a part of privacy, but it's not all of privacy. So when you hear of privacy regimes that are based on consent as an architecture, I can tell you right there, it's not a fulsome protection, because we need actual, consent comes at the end of a process. What's most meaningful is to have a voice at the beginning of the process. Imagine, for example, if you, instead of having the ability to opt in or opt out, had the ability to work in a voluntary consensus, a due process, situation to actually determine what data would be considered to give consent to in the first place. That's more power. That's more meaningful. I'd rather have a seat at the table any day than have a checkbox. So I think we need to balance things better. And that's a big misunderstanding. What is privacy? What is it really? It's not just consent. That being said, please balance that, understanding that consent in certain circumstances is absolutely essential. And we have to determine what those circumstances are. And for the rest, we've really got to find ways of making sure that we have architectures that allow us to have privacy on a much more standardized level, as opposed to doing this opt-in, opt-out as the main mechanism of privacy.
Yeah, that's a really good.
Sorry, Roslyn was about to say something earlier, and I accidentally muted her.
No, that's okay. Yeah, I can let Andrew go.
No, those are really good points, Pam. And I think, determining the narrow circumstances where, or the most important circumstances where consent should apply is a really important piece, particularly, as you said, as companies are collecting more data. I think a few things come to mind. This is more from the operational and compliance perspective that I find when I'm talking to state legislators, are often misunderstood. One is just how complex a company's data ecosystem is, and how that translates into the definition of personal data and things like access requests or correction, what a right to correction looks like. So, if the CCPA's definition of personal data, which was originally anything capable of being associated with, and now the outer boundary is anything reasonably capable of being associated with, if that's the test here, then that implicates far more data than a reasonably linked or reasonably linkable standard that's the FTC to an identified or identifiable person standard from GDPR. The marginal benefit of that data on the sort of outer edges that a company has versus the cost of trying to retrieve that and provide specific pieces of data. I think that's an imbalance that is hard to explain to legislators, and that there are misunderstandings about. I think the second piece is, fraud exemptions are really, a point of contention among, at the state level, and the breadth of a fraud exemption has been, really hotly debated, particularly in Washington last year. And then there was a bill in California last summer that was attempting to essentially take the fraud exemption that's in the right to delete and make it generally applicable to the whole statute. But I do think there's a misunderstanding about how prevalent and how paranoid companies are about data breaches, about fraud, about any kind of malicious activities that affect their ability to provide services and have consumer trust in their products. And so, you know, when on the compliance side, when I'm working on data breaches or when we're counseling clients on, you know, BIPA or, you know, pick a privacy statute, that, you know, it's really important that companies still have the ability, because the larger tech companies are under literally millions of attempts a day to infiltrate their networks, and they are spending enormous resources on that. And so I think it's important to keep that in mind. And then the third is that, you know, in my experience, companies genuinely want to comply with these laws. And so, you know, sometimes there's an attitude of, well, you know, we're going to try to get the broad strokes right here, but it doesn't matter what the bill actually says. We know what we're trying to do here, and you know, that should be enough. And for companies who are under threat of enforcement, under threat of sanctions or an investigation from, you know, the Attorney General, or, you know, private enforcement, it's really, they want to comply, and they are trying to do their best to meet the obligations that the statutes are imposing on them, and to have as narrow a compliance gap as possible. So I think a lot of the language around privacy negotiations for state legislation revolves around, oh, well, we know companies are going to try to evade these requirements. We know there are, you know, loopholes. We know that there are bad actors out there. But I think, you know, I wish there was more of a focus on how many businesses are trying really hard to comply with these, because that's the vast majority of my experience.
So I want to thank my colleagues. They've made so many great points that I think that it's helpful when we look from a European perspective and can make some comparisons. And I certainly want to highlight to everyone to please look at the work from Pam and Jane Wynn, their papers, the things they've worked on together, as well as an excellent paper by Jane Wynn on privacy pragmatism, which she describes in the democratic nature of American privacy. And I think that some of these comments illustrate that so well. What is interesting when we look at the European Union with the practice of GDPR is that the DPAs are practicing a risk-based enforcement. It isn't financially, humanly possible for these DPAs to prosecute every single infraction. They can't possibly absorb it or enforce it, so they have to decide what matters. And largely what matters reflects what people care about, and that is how they're funded. And I think what Andrew has rightly pointed out, that the states and the US have shifted to very specific instances, facial recognition, COVID-related issues. Instead of this kind of gigantic big privacy that Pam has talked about, it's very tailored, very specific to particular needs today. And I think that this does reflect, when it comes to voters, they will look at, you know, gee, I can't get to this website anymore, or the offers that I used to get I don't have now, or all these great apps I don't have anymore. That actually is being translated now to legislators, and that's why we see the kind of stepping back or rethinking. So, you know, that is actually reflecting democratic nature of American privacy law. It's, you know, more than 220 years old. So extensive in so many ways, so many sectors, 24 specific kinds of statutes, really thought through all the particular areas where it matters. And it's sometimes frustrating to read the sort of reports, you know, typical journalists might write, oh, the US doesn't have privacy protections or privacy laws. It's absolutely not the case. The things that people through the ballot box, what they care about, those have been quite protected. And certainly the capabilities that people have to pursue through private right of action and so many other ways. It's also worth mentioning that Federal Trade Commission has used a form of voluntary consensus standards through COPPA. It's been practiced quite a bit in a number of areas. We have many areas through the international standards bodies and through different standards organizations, ways to standardize, sorry to use this word a lot, but to put very specific discussions and descriptions of practices of business, so that there is a way to organize this, that you can study, that you can measure, that you can independently step back and say, gee, is that what's going on here? And I think that that's what Pam is getting at, of the importance of being able to measure things. And I would just want to close and say one more thing, which what's interesting, if we take this particular view that Pam is talking about with the voluntary consensus standards, and as an individual, how you would exercise your consent, if you think about the world that we're going into, there was on one hand this notion of, oh, set it, forget it, and the digital world's so difficult, and I'm just going to leave it to the regulator to sort it out, and it's all fundamental rights and so on. We're really talking about a world where the individual is much more engaged, is taking responsibility, is understanding what's going on with his or her data. And that is a world that involves education, it involves learning, it involves the person investing the time. And I think that that is another area that, as we think about this, and again, it's maybe not what policymakers want to legislate, but as users, as people who use technology, this in a certain way requires that we have to invest in it and learn about it for ourselves if we want to take these things seriously. But you know, and I think that those businesses who want to work with their customers to do those things and help them evolve, they will have, you know, they'll better customer experiences. They will, you know, the customers may ultimately use more of their services because they have greater sense of trust.
A question just to kind of pull things back to our original theme just a little bit. You know, is there anything specifically after 2 years of GDPR? You know, a lot of the problems were very obvious from the beginning, and you know, a lot of the predicted problems came true. And then, you know, after 1 year last year, we were able to see how they played out. Is there anything else that, you know, over the past year has become even more obvious or that was unexpected now that GDPR has had its terrible twos, as they call toddlers?
I'd like to take a stab at that. So something interesting that we haven't really talked about yet is just the extraordinary spread of GDPR clones. So according to Graham Greenleaf's estimate, he's an absolutely wonderful scholar, and he's kept track of all of the global legislation. There's 142 jurisdictions as of right now that have passed national data privacy legislation. And the majority of these, the vast majority of these they have incorporated either full copies of GDPR pretty much, or very similar. Now GDPR has evolved. The GDPR is being viewed as somewhat old now because although it was, you know, went into force 2 years ago, it had already been written and drafted, and the ideas were already out there. So it's, you know, it's got some age on it now, as one of the DPAs likes to say. So I think that the intriguing thing that's happened as the GDPR has spread to other jurisdictions is that the folks in other jurisdictions, for example, jurisdictions in Africa where there are DPAs and they have a very similar GDPR equivalent legislation in place, they're looking at real implementation struggles. And let me give you a precise example of this. So in GDPR, one of the things you're supposed to do is give proof of technological proof of compliance. Well, this is great if you have all that infrastructure to do that. But what about if you're in a jurisdiction where you're still on feature phones, you know, the flip phones at 2G? How are you going to provide, as a business, technological proof of compliance? So even the simplest things take on a different meaning. So what these DPAs, and this is, I'm finally getting to my point, the DPAs, what they've done is very clever. They've written implementation guides that are enormously practical for their jurisdiction. And I think that what we're seeing from this is a great blossoming of I would say contextualization of the GDPR, and it's changing it in each jurisdiction to suit their context. And I think the context, the social context of privacy law is quite important. We can't ignore it.
So before I introduce a question or two we have here for Q&A, I think Roslyn has written on this, but do you guys see a third way here? Is there some sort of way to sort this out other than passing one baseline federal bill, which looks pretty unlikely in an election year, and then as the panelists has pointed out, there are a lot of problems on the state side right now. Roslyn?
So I'm happy to say the Uniform Law Commission has taken up internet privacy as one of the issues it's working on. I think all of us may be involved in one way or another, but this is a very American institution. It is the organization which created the Uniform Commercial Code, the UCC, those who may be familiar. This is kind of in the practical way of how we do interstate commerce. So, all the states have some set of laws and how they do things, but we have to conform to the Constitution and be a nation. So the Uniform Law Commission steps in to help harmonize those things. And it's now looking at internet privacy or at this particular issue, and I think is quite a valuable organization. It's made up of commissioners from all of the 50 states and District of Columbia. And it is a process to help bring together the different concerns and as a way to help inform Congress as to help work out some of these things. I have an article in Forbes describing this, but you can check out the Uniform Law Commission to find out about this ongoing effort.
Okay, and we have a question. Sorry, my dog interrupted there. He has a lot to say about GDPR. He doesn't seem to like it very much.
I would just wanted to follow up on Roslyn's point. I maybe have a little bit less faith in the ULC process thus far than Roslyn. I'm hopeful that there will be a reasonable outcome. Right now, it's been a little bit sort of stuck in the mud and trying to get going and really deeply engage with some of the issues, but it is a very collaborative process, and it's also at a relatively low level of conflict, and I think that's a good level to try to make progress at. I would also just reiterate, I think if states want to get something done, they first need to, whether it's a committee, whether it's the governor, whether it's an attorney general, clearly articulate the problem that they are trying to go after, and then find legislators who are willing to really engage in the issues and do a lot of stakeholder outreach, because doing the work on the front end is a lot easier than introducing a bill that then filters up to everybody's public policy and legal departments and causes everybody to panic here. Doing the work on the front end is a much more productive process, and then introducing the legislation on the back end. I think also being patient and understanding that 1 3 or 4 month legislative session may not be enough time to get something accomplished, and so with being willing to have the long view and not considering it a failure if a bill doesn't pass the first time through.
I think those are all great points, and as far as the ULC process goes, it sounds like there's both a lot of potential and a lot of pressure on the ULC, given the surrounding circumstances, to actually get something out there that states will adopt. And it's very important right now that we do have some sort of privacy bill. I'm going to ask a question that I got here through a Q&A, and this one's directed to Andrew, and it says, Andrew mentioned legislative efficiency with the enactment of the CCPA compared with the amount of time it took the GDPR to be developed. Does he think the California legislature was really aware of what it was doing when it enacted the CCPA so quickly? For instance, how does the CCPA relate to other existing state and federal privacy statutes and state common law doctrines? Wasn't the California legislature just trying to prevent something worse from becoming law through the petition process?
Yes, so I was being a bit glib there when I said legislative efficiency, but yeah, no, I mean, I think, after the CCPA was passed, I talk about this a lot when I testify in other states and try to do outreach about what the CCPA process was. But after the CCPA was originally passed in June of 2018, there was a letter sent by 30 Democratic Assembly members and senators say, to leadership saying, we understand that there are lots of problems in here. We're going to need a lot of efforts to fix them, and that should be the focus of the following legislative session. So no, I don't think that anybody could really get through in over the weekend, although we all tried to really understand the implications of it. And I think anytime you have, I have done not very much GDPR compliance work, but I would bet the same is true for GDPR, that it's not until you really start digging into the statute and trying to build compliance programs that you realize where some of the tensions are, or where some of the pieces that need to be clarified are. So, we're still 6 months out, 6 months post the first set of statutory requirements being effective. And, there are any number of issues that have come up. I think, the idea of B2B companies who have very little consumer contact but have a public facing website, it's very likely that for that narrow act, that they're considered a business, right? If they meet the $25 million global threshold. So that means a whole set of compliance costs to address a website that nobody ever visits. So I think that would be an example of something that probably wasn't foreseen, when the bill passed. And I think there are plenty of examples of that, but no, I was just being glib when I said legislative efficiency. If anybody on the call works in state government affairs, that, it's often a long process from introduction to passage. So no, I think, we'll see what happens, but we've got the next ballot initiative that everybody can also start making their way through, because that looks like it's likely to get on the ballot in November.
Ashley, may I respond to the third way question?
Yes.
So just very, very briefly, if you really study the GDPR and some of the other data protection statutes that are running around, they always run into a couple of philosophical roadblocks. I'm not going to go into detail on this. I'm happy to email with anyone about this though. But one of the problems is you basically are coming out with a very theoretical framework. And in the end, either a company or a data protection authority or a data protection officer has to make these practical and everyday in everyday life. And one of the things that is becoming clearer is that a smaller bill with more tools for measurements, standards, like there are in security practices, with more tools and with more practical tools for applying things is something that would be very helpful. If we have a rights-based structure, it can really get messy in the implementation, and it's left up in a GDPR, that's left up to codes of conduct. So again, if you look at what the UK is doing now, they've got the GDPR essentially because of pre-Brexit, and they're doing a beautiful job implementing it with these absolutely fulsome codes of conduct that are very fair and very protective, but they're also enormously practical. I mean, to the nth degree. They're not prescriptive, but they're practical. And it really provides a guidance as to what's acceptable and what's not at the ground level. And I think that this is a very important thing to look at as we strive for a third way.
Yeah, just to echo Pam, I think practicality and flexibility are really important. I think there's sort of a concept of, you don't want to try to hold the fish too tightly, right? Because that's when it kind of gets away from you. I think being able to allow, for different models, different sectors, different industries, while laying some clear ground rules is a pretty effective framework.
So we have one more question, which is obviously all we're going to have time for. I also want some, final closing thoughts. I'm going to, ask you guys the questions, and you guys can also include any remaining thoughts you have. But the question is, do you think any bill has a chance of passing if it contains a private right of action? What if it is an extremely limited right, which has well-defined safe harbors?
I don't know, Roslyn, do you want to take a
I mean,
think about?
anything's possible, but again, the other part is, that is the privacy litigation bar. They are the ones pushing this, pushing this kind of a provision inside of the bill. I have seen and discussed how you can sort of kneecap it so it's not abused. But I would also say in a kind of post-COVID world, the notion of this sort of, well, I mean, again, we may have all kinds of runaway litigation. I'm not.
You're on mute, Roslyn.
You're on mute, Roslyn.
Yeah, I'm going to let you take it. Go ahead.
Yeah, I mean, I think it depends on the state. I think it's possible for a deep blue state to just kind of shut its eyes and close its ears and go ahead and pass something with a private right of action. I mean, I think it's possible. I think Roslyn's point is very well taken, that states are going to be very concerned about the impact on the business community and getting folks back to work. When we're talking about 30%, 35% unemployment nationally, I think that's, states are going to be very, very attuned to minimizing impact on businesses like that. The other thing I would say is, I think from the business community standpoint, it just doesn't really make sense to have private rights of action at a state level, because you're talking about 50 different jurisdictions. And so trying to litigate in 50 different jurisdictions, trying to understand where the case law is going to go and how to apply that, in a federal district court that may cover lots of different states or something along those lines. I just don't see it happening. At the federal level, is there a little bit more room for negotiation? I don't know, maybe, but I think at the state level, it just really doesn't make a lot of sense. So that I would be very disappointed if a bill with a private right of action passed.
Of course, this question really gets to the nub of what happened in the Washington state bill.
Sure.
For anyone who wants to see how this question played out in Washington, it would be really well worth reading the legislative history. It was really very messy, and there are very clear lines. I think that a lot of consumer advocates want a private right of action. A lot of folks in the business community do not want a private right of action. Some state AGs do want one, some state AGs don't want one. I, of course, am very interested in a middle ground somewhere and finding a way to do that. The state of Oregon had a very interesting situation. In one of our, kind of the second to the last meeting, a representative got on the phone and basically said, hey, we can't fund a privacy bill because of the pandemic. It's a very significant budgetary situation. And that legislator recommended that, a middle ground was found on PRA. I don't know the answer here, but I can promise you one thing. Any discussion about any bill, if it includes enforcement that has a PRA, is going to be much more contentious. That's the one factual thing I can say, and it certainly becomes more difficult to pass. But I don't think it means it's impossible.
No, I mean, I think we saw it in Washington where, the existence of that enforcement mechanism ends up overwhelming the substantive debate on what rights should look like, what a framework should look like, what the actual substance of the bill should look like, because it's, right now a red line for the business community, but it's also a bright line for the privacy advocates. I think, so that's where I end up.
I would say I agree with that. So it looks like we're out of time here. Great job, everyone. I think that was a really productive discussion, which is something we need to have a lot more of, I feel like, in this privacy debate. For those of you who it's your first time joining us for one of these panels, the Committee for Justice hosts these every Thursday. usually at 1 o'clock. And our topic next week is going to be, we're going to do a review of the remaining undecided Supreme Court cases for this term, which should be a lot of fun. So feel free to come back and join us for that. And thank you for tuning in today.
Thank you all.
Thanks so much, Ashley. Thanks, Pam. Thanks, Roslyn.
Thank you, guys.